it. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
Hey guys, welcome back to another video. Now, today we're here to talk about and go over a very touchy subject, and it has to do with Angie Stone. Now, for those who are not aware or who don't remember, back in March of this year, there was a fatal tragic accident that had happened with Angie Stone on her Sprinter as she was doing traveling, as she was doing a tour. And this lawsuit was filed on behalf of her children, Diamond Stone and Michael D'Angelo Archer II. Now, they filed this lawsuit on September the 2nd, and we're going to get into the actual court documents. So, as you see below, under copyright disclaimer, under Section 107, I am simply saying that I am not an attorney, I am not a paralegal, and I am not a judge. I am simply saying that, hey, I know how to read. And without further ado, here is the lawsuit. So let's go ahead and get right into it. We're going to go right here to introduction. Now, this is a pretty lengthy lawsuit. There is 41 pages, so bear with me, okay? So let's get into the introduction. In the early morning hours of March the 1st, 2025, Grammy-nominated R&B singer Angela Laverne, Angie Stone, and a group of her bandmates and family members, including Sheila Hopkins, were traveling through Montgomery County, Alabama, after leaving a performance the night before in Mobile, Alabama. Angie's group was riding in a 2021 Mercedes-Benz Sprinter van owned by defendants Good To Go Cafe LLC, Executive Elite Transportation LLC, or Joseph L. Robinson, and driven by defendant Lethal Carter, who had been hired to transport Angie and her group from Atlanta, Georgia, to the performance in Mobile and then back to Atlanta. While traveling north on I-65, defendant Carter lost control of the Sprinter van, causing the van to exit the roadway to the left. As defendant Carter attempted to steer the Sprinter van back to the right and onto the interstate, the Sprinter van overturned onto its driver's side and came to rest in the left lane of I-65 North. The right lane of I-65 North was open and not obstructed by the disabled Sprinter van. Angie Stone and Sheila Hopkins, who were both properly belted in rear-facing seats behind the front driver and passenger seats, survived the initial collision without serious injury, as did the other occupants of the Sprinter van. During the next several minutes, all the passengers, including Angie Stone and Sheila Hopkins, attempted to get out of the overturned Sprinter van. Now, during this time, the headlights, taillights, and running lights of the Sprinter van remained on. Because they were paying proper attention to the roadway in front of them and not driving too fast for the conditions, several other motorists traveling northbound on I-65 saw the overturned Sprinter van and safely drove their vehicles around it in the open right lane. Other motorists paying proper attention to the roadway also saw the overturned Sprinter van pulled over to the right shoulder of the interstate and put their four-way flashers on. With the help of these good Samaritans, 5 of the 9 occupants were able to exit the Sprinter van. At around 4:25 a.m., a large CRST tractor trailer driven by defendant Jared Wilkinson was proceeding in the left fast lane of travel on I-65 North. Defendant Wilkinson was on his way to deliver a load of sugar to Forest Park, Georgia. The CRST tractor Wilkinson was driving was a 2021 Freightliner equipped with Detroit Assurance 5.0, a collision mitigation system designed, manufactured, marketed, and sold by defendants Daimler Truck North America LLC and Detroit Diesel Corporation. The Detroit Assurance 5.0 collision mitigation system is marketed and advertised as a system that will warn tractor trailer drivers of moving and stationary objects in the roadway, partially brake their tractor trailer, and then fully brake the tractor trailer if the driver does not respond. Because defendant Wilkinson was not paying proper attention to the roadway ahead of him, and because the Detroit Assurance 5.0 collision mitigation system did not warn Wilkinson of the disabled Sprinter van or automatically brake the CRST tractor trailer, Wilkinson slammed the front of the CRST tractor trailer into the disabled Sprinter van at highway speeds without ever applying the brakes. At the time, the CRST tractor trailer slammed into the overturned Sprinter van. Both Angie Stone and Sheila Hopkins were still inside and trying to get out of the van. The force of the impact was extremely severe. As a result of the collision, Angie Stone was ejected from and pinned underneath the Sprinter van. Angie Stone remained trapped underneath the van, where she consciously suffered until she ultimately succumbed to the fatal injuries she sustained in the collision and died. This is gonna get touchy. This is gonna get very touchy. Okay, so let's keep reading. The claims asserted by plaintiffs arise out of the events described above. Michael D'Angelo Archer II, a Georgia resident, is a surviving child and the duly appointed administrator of the estate of Angie Laverne, Angie Stone, deceased. Diamond Stone is also a surviving child of Angie Stone. Plaintiffs Michael D'Angelo Archer II and Diamond Stone are the only surviving children of Angie Stone, deceased. Angie Stone was a Georgia resident. And then it says plaintiff Sheila Hopkins is a Texas resident. Defendant CRST Expedited Inc. CRST, the Transportation Solution Inc., is a foreign corporation authorized to do business in the state of Georgia. CRST's principal place of business is located at 3930 16th Avenue Southwest, Cedar Rapids, Iowa 52404. CRST maintains a registered agent in the state and may be served with legal process by serving its registered agent, the corporation company. 410 Peachtree Parkway, Suite 4245, Cumming, Forsyth County, Georgia 30041. This court has jurisdiction over defendant CRST because it is authorized to and does transact business in the state of Georgia. CRST is engaged in business as an interstate motor carrier transporting goods for compensation with registered U.S. dot number 53773 and routinely does business in and through Georgia. Venue is proper in this court as to defendant CRST because venue is proper with respect to Daimler Truck North America LLC, a joint tort feasor. Defendant Jared Seth Wilkinson is a Texas resident with a last known address. Okay, so we'll just skip over that part, but y'all can see his address there, where he may be personally served with legal process pursuant to, and then it says OCGA 91094, which is that's the actual law, and other applicable law. Defendant Wilkinson routinely works and regularly transact business throughout the state of Georgia and was en route to make a delivery to Forest Park, Georgia at the time of the fatal collision. Defendant Wilkinson is subject to the jurisdiction of this court because he is a non-resident who transact business in the state and caused tortious injury in the state pursuant to OCGA 9-10-91 and other applicable law. Venue is proper in this court as to defendant Wilkinson because venue is proper with respect to Daimler Truck North America LLC, a joint tortfeasor. Defendant Daimler Truck North America LLC is a foreign company authorized to do business in the state of Georgia. Daimler's principal place of business is located at 4555 North Channel Avenue, Portland, Oregon, 97217. Daimler maintains a registered agent in the state and may be served with legal process by serving its registered agent, CT Corporation System. And then that's the address, y'all. Okay, so it looks like some of this stuff is personal information. So we're just going to skip over some of this part because it's just giving the names and then the addresses. So we're just going to skip over this part. I think some of this does look like personal information. So let me just keep scrolling. I will link this actual court document in the description box below. You can read it on your own accord, but let's go ahead and continue. So we have operative facts. During the early morning hours of March the 1st, 2025, Angie Stone, Sheila Hopkins, and a group of Angie's bandmates and family members were driving through Montgomery County, Alabama, traveling back to Atlanta, Georgia from a musical performance in Mobile, Alabama. Angie and Sheila were properly belted passengers in a 2021 Mercedes-Benz Sprinter van heading north on I-65. The Sprinter van was owned by defendants Good to Go Executive Elite or Robinson and driven by defendant Lethal Carter, who was hired to transport Angie's group from Atlanta to Mobile and then back to Atlanta. While traveling north on I-65, defendant Carter lost control of the Sprinter van, causing the van to exit the roadway to the left as defendant Carter attempted to steer the Sprinter van back to the right and onto the interstate. The Sprinter van overturned onto its driver's side and came to rest in the left lane of I-65 North. So basically, this is repeating what we just read in the actual introduction. So we're going to scroll through and get down to the next topic. So as y'all can see here, we've read this above. Okay, so this is new here. So we're going to start right here on 55, okay? It says the brakes on the CRST tractor trailer were never applied by Wilkinson or the Detroit Assurance 5.0 collision mitigation system. And the tractor trailer was going nearly 70 miles per hour upon impact with the Sprinter van. The impact of the CRST tractor trailer hitting the Sprinter van was extremely severe. This is a very touchy subject, as I mentioned, y'all. As a result of the collision, Angie Stone was ejected from the Sprinter van and pinned underneath the van. So we're just going to scroll on. It says Ms. Hopkins miraculously survived the collision but suffered injuries for which she was immediately treated at Baptist South Hospital in Montgomery, Alabama, and for which she is still being treated. Defendant CRST selected listed specifications for owned, maintained, repaired, and controlled the 2021 Freightliner Cascada, driven by defendant Wilkinson. Okay, so it shows here defendant CRST negligently and recklessly permitted its tractor trailer to be driven by defendant Wilkinson on the morning of the collision. Defendant CRST neglectedly trained, qualified, screened, hired, selected, dispatched, and supervised defendant Wilkinson. At the time of the subject collision, defendant Wilkinson was driving the CRST tractor trailer to Georgia to make a delivery in Forest Park, Georgia. At the time of the subject collision, defendant Wilkinson was an employee and or agent of CRST and was operating the subject tractor trailer in the scope of his employment and or agency with CRST and in furtherance of CRST's business. Defendant Wilkinson was following too closely, distracted, fatigued, not paying proper attention to the roadway, and or driving too fast for conditions at and around the time of the subject collision. The Detroit Assurance 5.0 collision mitigation system did not warn defendant Wilkinson of the overturned Sprinter van, automatically brake the tractor trailer, or perform as it was marketed and advertised. The fatal wreck was caused by a negligent and or reckless acts and or omissions of the defendants, either alone or in conjunction with one another. The wreck was foreseeable to the defendants and could have been avoided had the defendants acted in a safe and prudent manner as required by law in accordance with the applicable standards. The collision was directly and proximately caused by the actions and negligence of the defendants, either alone or in conjunction with one another. Angie Stone was a totally innocent victim who in no way contributed to causing the wreck or the fatal injuries she sustained. Sheila Hopkins was a totally innocent victim who in no way contributed to causing the wreck or the serious injuries she sustained. No non-party contributed to causing the subject collision. Okay, so we have a few counts here, as y'all can see. Liability of defendants. So this is count one. Let's get into it. Right here on line 74. We are currently on page 15, if you would like to follow along on your own, if you're in the background just listening in, or if you just want to read along. We are now on page 15 of 41. Okay, so we're going to start right here on 74. Plaintiffs reallege and incorporate each of the above numbered paragraphs as if fully set forth herein verbatim. Defendant Wilkinson had a duty to operate the tractor trailer he was driving in a safe and prudent manner so as not to endanger the lives and welfare of Angie Stone, Sheila Hopkins, and the motoring public. This duty included keeping a proper lookout while driving, paying proper attention, moving over and yielding to disabled vehicles, and operating the tractor trailer prudently in accordance with the conditions of the roadway and all traffic laws and regulations. As a commercial truck driver, defendant Wilkinson also had a duty to operate the tractor trailer in conformance with the state and federal motor carrier safety regulations and the industry and corporate standards arising out of these regulations, including but not limited to the required skills and knowledge set forth in 49 CFR 390-396. Defendant Wilkinson breached his duties and is liable for his torturous acts and omissions, which include but are not limited to the following. So it gives bullet points. So as y'all can see here, there's a few bullet points. So we're going to go over them all. So the first one, or A, it shows violating pertinent rules of the road, which such violations amounting to negligence per se. The pertinent violations include, but are not limited to, the following. 1, failing to operate his vehicle with due care and caution. 2, operating the tractor trailer carelessly and heedlessly in willful or wanton disregard for the rights or safety of persons or property. 3, following too closely and failing to yield to other vehicles, including the disabled Sprinter van. 4, driving too fast and at a speed greater than was reasonable and prudent under the conditions. 5, failing to move over and go around the disabled vehicle. 6, failing to operate the tractor trailer in accordance with the laws, ordinances, and regulations of the jurisdiction in which it was operated in violation of 49 CFR 392.2 and other laws and regulations. 7, unlawfully and negligently operating a commercial motor vehicle while distracted in or fatigued in violation of the state and federal laws and safety regulations, including but not limited to 49 CFR 392.3, and 8, violating certain other rules of the federal motor carrier safety regulations. And as y'all can see there, that is the acronym FMCSR, as adopted by state law, which violations also amounting to negligence per se. And then B, failing to operate the tractor trailer in a safe and prudent manner, thereby placing the lives and well-being of the public in general and Angie Stone and Sheila Hopkins in particular in danger. C, failing to keep a proper lookout and or pay attention to the roadway, thereby placing the lives and well-being of the public in general and Angie Stone and Sheila Hopkins in particular in danger. D, failing to use ordinary care under their circumstances to avoid the subject collision. E, operating the large tractor trailer too fast for the conditions. F, the tractor trailer despite knowing it was in an unsafe condition. G, failing to use and or possess the knowledge and skills necessary to operate a commercial motor vehicle safely. H, failing to use proper visual search methods while operating a commercial motor vehicle as required by the federal motor carrier safety regulations and or industry standards. I, failing to use proper space management techniques as required by the federal motor carrier safety regulations and or industry standards. J, failing to use proper hazard perception techniques as required by the federal motor carrier safety regulations and or industry standards. K, failing to take reasonable evasive action to stop and or avoid the subject collision. L, failing to inspect and or operate the tractor trailer in compliance with state and federal law and regulations. And M, other acts of negligence to be revealed during discovery. And then, as y'all see right here on 78, as a direct and proximate result of the foregoing breaches of duties, Angie Stone suffered the loss and injuries, note herein, consensually suffered physical and mental pain and ultimately died. As a direct and proximate result of the foregoing breaches of duties, Sheila Hopkins suffered the losses and injuries noted herein, along or in conjunction with the negligence of the other defendants. Defendant Wilkinson's negligence proximately caused Angie Stone's death and the injuries and damages to plaintiffs. Defendant Wilkinson's misconduct is so aggravating, it authorizes, warrants, and demands the imposition of substantial punitive damages. Count 2. So right now we're on page 18 going to page 19. So count 2 is defendant CRST's negligence. Defendants re-allege and incorporate each of the above numbered paragraphs as it fully set forth here verbatim. At the time of the subject collision, defendant Wilkinson was an employee of CRST and was acting in the scope of his employment with CRST. Defendant CRST is liable under the doctrine of respondent superior for the tortious acts and omissions of its agents, employees, or servants. These acts and omissions include, but are not limited to, the acts and omissions committed by defendant Wilkinson on March the 1st, 2025. CRST negligently selected, hired, trained, supervised, retained, qualified, dispatched, and or entrusted defendant Wilkinson as a driver of a commercial motor vehicle. CRST controlled the time, manner, and method of defendant Wilkinson's work at all relevant times, including on March the 1st, 2025. CRST knew or should have known that defendant Wilkinson was not competent, qualified, or fit to drive a commercial motor vehicle, and that doing so put others in danger. Notwithstanding such knowledge, defendant CRST hired and failed to terminate defendant Wilkinson prior to the subject collision. Defendant CRST failed to ensure that the subject trailer or tractor trailer and driver complied with all applicable laws, regulations, and industry standards. Defendant CRST failed to implement and enforce means to prevent its drivers, including defendant Wilkinson, from operating unsafely or in violation of applicable law, regulations, and or rules that a reasonable and prudent motor carrier would have implemented and enforced. Defendant CRST wrongfully and negligently operated a commercial carrier with inadequate and or ineffective safety management controls. Defendant CRST negligently and recklessly permitted the tractor trailer to be driven on public roadways with inadequate and inoperable safety features or in an unsafe condition in violation of applicable law or industry standards. Defendant CRST was negligent in failing to properly maintain or repair the 2021 Freightliner safety system, including the collision mitigation system and or its components, with such negligence causing or contributing to causing the safety system to not function properly at the time of the subject collision. As a direct and proximate result of the foregoing breaches of duties, Angie Stone suffered the losses and injuries noted herein. I just reading this actual court document. This is sad. This is sad. This is sad. But we're going to continue, y'all. So, consensually suffered physical and mental pain and ultimately died. As a direct and proximate result of the foregoing breaches of duties, Sheila Hopkins suffered the losses and injuries noted herein, along or in conjunction with the negligence of the other defendants. Defendant CRST's negligence proximately caused Angie Stone's death and the injuries and damages to plaintiffs. Defendant CRST's misconduct is so aggravating, it authorizes, warrants, and demands the imposition of substantial punitive damages. Okay, so now we are into count 3, which is strict products liability and negligence as to defendant Daimler, or how do you say that? Daimler. Plaintiffs reallege and incorporate each of the above numbered paragraphs as it fully set forth here verbatim. At all times, material hereto, including March 1st, 2025, Daimler, I'm going to say Daimler, yep, that's how it is. Okay, but anyway, let's continue. Was engaged in the business of designing, testing, manufacturing, distributing, promoting, advertising, marketing, and selling commercial motor vehicles and other goods, including the 2021 Freightliner Cascadia involved in the subject collision, which were placed into the stream of commerce and used in the state of Georgia on public roadways. Daimler had a duty to exercise due care in the design, manufacture, assembly, distribution, and sale of the subject 2021 Freightliner Cascadia, and to ensure that the subject 2021 Freightliner that it placed in the stream of commerce met the reasonable expectations of ordinary consumers and was safe for use by its intended users and those persons who may foreseeably come into close proximity to it, including others on the public roadways, such as Angie Stone and Sheila Hopkins. Daimler breached its duties, which caused plaintiffs injuries and damages as detailed herein. At the time of the design, manufacture, distribution, delivery in the stream of commerce, and or sale of the 2021 Freightliner Cascadia, it lacked a properly designed system for crash avoidance. The subject 2021 Freightliner Cascadia was defective and unreasonably dangerous at the time it was designed, manufactured, assembled, sold, distributed, marketed, promoted, placed in the stream of commerce and marketplace, and allowed to be used therein. At the time Daimler placed the 2021 Freightliner Cascadia into the stream of commerce, Daimler knew or should have known that the Freightliner's collision mitigation safety system would not properly and safely warn drivers or avoid or mitigate collisions with other vehicles like the Sprinter van it collided with on March 1st, 2025. At all relevant times and prior to the subject collision, Daimler knew its 2021 Freightliner Cascadia posed a significant risk of duty and death to roadway users, but failed to warn about those dangers or make appropriate changes to remedy the defective nature of the subject product. The 2021 Freightliner Cascadia defective safety system, including a Detroit Assurance 5.0 collision mitigation system with active brake assist 5. And y'all see the acronym there, which is advertised and supposed to utilize radar and camera technology to monitor the road and automatically warn the driver and or apply partial or full braking to avoid or mitigate potential collisions. Defendant Daimler placed the 2021 Freightliner Cascadia equipped with the Detroit Assurance 5.0, including ABA 5, into the stream of commerce. ABA 5 is promoted and advertised by Daimler as providing audio and visual warnings, as well as full braking on moving and stationary vehicles. So as y'all see here, this is the active brake assist. Okay. And y'all see here go a hyperlink. So this hyperlink would actually take you into the website that's going over this assurance system. Now, on your own, you can click on the hyperlink. The actual court document, as I mentioned, will be in the description box, but we're going to go ahead and continue. We're on page 23 of page 41, but we're going to continue, okay? So at the time that defendant Daimler placed the 2021 Freightliner Cascadia equipped with the Detroit Assurance 5.0 into the stream of commerce, Daimler knew or should have known that the subject Freightliner safety system was defective and unreasonably dangerous for its intended or reasonably foreseeable uses and would not properly and safely avoid collisions with vehicles and other objects like the disabled Sprinter van by issuing audio and visual warnings or activating the brakes. At the time of the subject collision, the 2021 Freightliner Cascadia equipped with Detroit's Assurance 5.0 and specifically the ABA 5 technology was defective and failed to issue an audible and visual warning to the driver, but failed to apply any partial or full braking in response to the Sprinter van that was disabled in the left lane of I-65 northbound. The subject 2021 Freightliner safety system was defective and did not provide any audio or visual warning to the driver or apply any partial or full braking in response to the Sprinter van that was disabled in the left lane and directly in front of the subject 2021 Freightliner Cascadia. The Detroit Assurance 5.0 collision mitigation system was equipped on the 2021 Freightliner Cascadia, and specifically ABA5 was defective in its design, manufacture, and warnings, and failed to work for its intended purpose when it failed to detect, issue an audio or visual warning, or engage partial or full brakes when it encountered the disabled Sprinter van. Daimler negligently designed, manufactured, promoted, marketed, advertised, monitored, and sold the subject 2021 Freightliner Cascadia equipped with Detroit Assurance 5.0, a collision mitigation system, to consumers like defendants CRST and Wilkinson, who wrongfully believed that the system would work as it was marketed and advertised. The negligence, negligence of Daimler and defects of the 2021 Freightliner Cascadia safety system, including the defective Detroit Assurance 5.0 collision mitigation system, along with the acts and omissions of the other defendants, proximately caused Angie Stone's death and the injuries and damages to plaintiffs. Defendant Daimler acted with reckless disregard for the safety and well-being of the public, and acted willfully and only in designing, testing, manufacturing, inspecting, marketing, distributing, selling, monitoring, and failing to effectively recall or repair the subject 2021 Freightliner Cascadia safety system, including the Detroit Assurance 5.0 and or ABA 5. Such conduct warrants the imposition of punitive damages against Daimler as a direct and proximate result of the foregoing breaches of duties. Angie Stone suffered the losses and injuries noted herein, consensually suffered physical and mental pain, and ultimately died as a direct and proximate result of the foregoing breaches. So this is just repeating each count at the very end. It says alone or in conjunction with the negligence of the defendants, defendant Daimler negligence and defects in the Detroit Assurance 5.0 collision mitigation system proximately caused Angie Stone's death and the injuries and damages to plaintiffs. So now we're on count 4, okay, page 26 of 41. Count 4, failure to warn as to defendant Daimler. Plaintiffs re-allege and incorporate each of the following numbered paragraphs as if fully set forth here in verbatim at all times. Material hereto, including March 1st, 2025. Daimler was engaged in the business of designing, testing, manufacturing, distributing, promoting, advertising, monitoring, and marketing the 2021 Freightliner Cascadia and Detroit Assurance 5.0 collision mitigation system that was installed on the subject Freightliner owned by defendant CRST and driven by defendant Wilkinson. At the time of the 2021 Freightliner Cascadia and Detroit Assurance 5.0 collision mitigation system left defendant Daimler's control and entered the stream of commerce. It was defective and unreasonably dangerous due to defendant's failure to provide inadequate warnings or instructions regarding the foreseeable risk of harm associated with its use. Defendant Daimler held out the 2021 Freightliner Cascadia safety system, including the Detroit Assurance 5.0, as the ultimate in safety, and advertised that its ABA 5 technology mitigates potential collisions and can identify moving or stationary vehicles in the truck's path. Daimler marketed and sold this product to consumers, and in doing so, instructed consumers that it was imperative that they accept and put their trust in the Detroit Assurance 5.0 collision mitigation system. Daimler knew or should have known that these claims were not accurate or safe, and that users of the 2021 Freightliner Cascadia equipped with Detroit Assurance 5.0 would not recognize the danger posed by the product. Daimler knew or should have known that drivers like Defendant Wilkinson and companies like CRST would place their trust in Daimler and rely on the Detroit Assurance 5.0 system to work as advertised, warn them of stationary objects like the disabled Sprinter van, and apply partial or full braking to prevent or mitigate collisions like the March 1st, 2025 collision. Daimler knew or should have known that drivers like Defendant Wilkinson and companies like CRST would rely on the Detroit Assurance 5.0 collision mitigation system to warn them of stationary vehicles and otherwise perform as it was marketed and advertised. Daimler's failure to warn consumers and purchasers of problems it knew about and defects of Detroit Assurance 5.0 and failure to inform consumers and purchasers that the 2021 Freightliner Cascadia safety system would not detect vehicles like the disabled Sprinter van and the condition it was in on March 1st, 2025, along with the acts and omissions of the other defendants. Proximately caused the injuries, damages, and losses that plaintiffs have suffered, as well as the death of Angie Stone. Defendant Daimler acted with recklessness, disregard for the safety and well-being of the public, and acted willfully and one only in failing to warn consumers of the shortcomings of Detroit Assurance 5.0. Such conduct warrants the imposition of punitive damages against Daimler. As a direct and proximate result of the foregoing breaches of duties, Angie Stone suffered the losses and injuries noted herein, consciously suffered physical and mental pain, and ultimately died. So this is just a repeat, as y'all seen in the other accounts. So we're going to go ahead and go over to count 5. So we're almost on page 30. So count 5 is strict products liability and negligence as to defendant Detroit Diesel. Plaintiffs reallege and incorporate each of the above numbered paragraphs as if fully set forth herein verbatim at all times. Material hereto, including March 1st, 2025. Defendant Detroit Diesel was a subsidiary of defendant Daimler and was engaged in the business of designing, testing, manufacturing, distributing, promoting, advertising, monitoring, and marketing diesel and electric engines, axles, transmissions, and safety systems, including the Detroit Assurance 5.0 collision mitigation system that was installed on the CRST tractor trailer driven by defendant Wilkinson. Defendant Detroit Diesel had a duty to exercise due care in the design, manufacture, assembly, distribution, and sale of the Detroit Assurance 5.0 collision mitigation system, and to ensure the product that it placed in the stream of commerce met the reasonable expectations of ordinary consumers and was safe for use by its intended users and those persons who may foreseeably come into proximity to it, including others on the public roadways, such as Angie Stone and Sheila Hopkins. Defendant Detroit Diesel breached its duties, which caused plaintiff injuries and damages detailed herein. Defendant Detroit Diesel placed the Detroit Assurance 5.0, including ABA 5, into the stream of commerce. At the time defendant Detroit Diesel placed the 2021 Freightliner Cascadia and Detroit Assurance 5.0 into the stream of commerce, Detroit Diesel knew or should have known that they were defective and unreasonably dangerous for their intended or reasonably foreseeable uses and would not properly and safely avoid collisions with vehicles and other objects by issuing audio and visual warnings or automatically applying the brakes. At the time of the subject collision, Detroit Assurance 5.0, and specifically the ABA 5 technology, which was installed on the CRST tractor trailer, failed to detect the disabled Sprinter van, failed to issue an audible or visual warning to the driver, and failed to apply any partial or full braking. Detroit Assurance 5.0, and specifically ABA 5, was defective in its design, manufacture, and warnings, and failed to work for its intended purpose, when it failed to detect, issue inaudible or visual warning, or engage partial or full brakes when it encountered the overturned Sprinter van. Detroit Diesel uh, negligently designed, manufactured, marketed, advertised, monitored, and sold the 2021 Freightliner Cascadia in Detroit Assurance 5.0 collision mitigation system to consumers like Daimler, CRST, and Wilkinson, who wrongfully believed that the system would work as it was marketed and sold. The negligence of Detroit Diesel and its defects of the Detroit Assurance 5.0 collision mitigation system, along with the acts and omissions of the other defendants, proximately caused the injuries, damages, and losses that plaintiffs have suffered, as well as the death of Angie Stone. Defendant Detroit Diesel acted with reckless disregard for the safety and well-being of the public and acted willfully and one only in designing, testing, manufacturing, inspecting, marketing, distributing, selling, monitoring, and failing to effectively recall or repair the 2021 Freightliner Cascadia, Detroit Assurance 5.0, and or the ABA 5. Such conduct warrants the imposition of punitive damages against Detroit Diesel. And so this is just a repeat at the very end, as y'all see here, 142, 143, 144. That seems to be the repeat of each count. So let's go ahead and get into count 6. Count 6 is failure to warn as to defendant Detroit Diesel. Plaintiffs allege and incorporate each of the above numbered paragraphs as if fully set forth herein. At all times, material hereto, including March 1st, 2025. Detroit Diesel was engaged in the business of designing, testing, manufacturing, distributing, promoting, advertising, monitoring, and marketing the Detroit Assurance 5.0 collision mitigation system that was installed on the CRST tractor trailer driven by defendant Wilkinson. At the time, the 2021 Freightliner Cascadia and Detroit Assurance 5.0 collision mitigation system left defendant Detroit Diesel's control and entered the stream of commerce. It was defective and unreasonably dangerous due to defendant's failure to provide adequate warnings or instructions regarding the foreseeable risk of harm associated with its use. Defendant Detroit Diesel held out Detroit Assurance 5.0 as the ultimate in safety and advertised as its ABA 5 technology mitigates potential collisions and can identify moving or stationary vehicles in the truck path. Daimler marketed and sold these products to consumers and instructed consumers that it was imperative that they put their trust in these features. Detroit Diesel knew or should have known that these claims were not accurate or safe, and that users of Detroit Assurance 5.0 would not recognize the danger posed by its product. Detroit Diesel knew or should have known that drivers like defendant Wilkinson and companies like CRST would place their trust in the Detroit Assurance 5.0 system and rely on it to work as advertised, warn them of stationary objects like the disabled Sprinter van, and apply partial or full braking to prevent or mitigate collisions like March the 1st, 2025 collision. Detroit Diesel knew or should have known that drivers like defendant Wilkinson and companies like CRST would rely on the Detroit Assurance 5.0 collision mitigation system to warn them of stationary vehicles and otherwise perform it as it was marketed and advertised. Detroit Diesel's failure to warn consumers and purchasers of problems it knew about and defects of Detroit Assurance 5.0 and failure to inform consumers and purchasers that system would not detect vehicles like the disabled Sprinter van in the condition it was on March 1st, 2025. Along with the acts and omissions of the other defendants, proximately caused the injuries, damages, and losses that defendants have suffered, as well as the death of Angie Stone. Defendant Detroit Diesel acted with reckless disregard for the safety and well-being of the public and acted willfully and one only on in failing to warn consumers of the shortcomings of the 2021 Freightliner Cascadia in Detroit Assurance 5.0. Such conduct warrants the imposition of punitive damages against Daimler. So again, this is just a repeat of the other counts. So we're going to get into count 7. So count 7 is about defendant lethal Carter's negligence. Okay, so that's a repeat. Okay, so here we go. Defendant Carter was hired to transport Angie Stone, Sheila Hawkins, and others in the Sprinter van from Atlanta, Georgia to Mobile, Atlanta, and then back to Atlanta. As such, defendant Carter was a carrier of passengers. Defendant Carter had a duty to operate the Mercedes-Benz Sprinter van he was driving in a safe and prudent manner so as not to endanger the lives and welfare of his drivers, including Angie Stone and Sheila Hopkins, and the motoring public. This duty included keeping a proper lookout while driving, paying proper attention, remaining alert, and operating the Sprinter van prudently and in accordance with the conditions of the roadway and all traffic laws and regulations. Defendant Carter breached his duties and is liable for his torturous acts and omissions, which include but are not limited to the following. So let's get into A. Violating pertinent rules of the road, which such violations amounting to negligence per se. The pertinent violations include but are not limited to the following. A, which is still A1. Failing to operate the Sprinter van with due care and caution. Okay, so let's go to B. Failing to operate the Sprinter van in a safe and prudent manner, thereby placing the lives and well-being of the public in general, and Angie Stone and Sheila Hopkins in particular in danger. C. Failing to keep a proper lookout and or pay attention to the roadway, thereby placing the lives and well-being of the public in general, and Angie Stone and Sheila Hopkins in particular in danger. D. Failing to use ordinary and extraordinary care under the circumstances to avoid the subject collision. And E. Other acts of negligence to be revealed during discovery. Okay, so as y'all can see, we're going to move over to count 8. That's a repeat. So count 8 is defendant Joseph L. Robinson, good to go, and executive elite negligence. Okay, so that's a repeat. So we're going to go right here to 167. It says defendant Robinson, good to go, and or executive elite had a business relationship with defendant Carter, whereby they had an agreement to share revenue from Carter's use of the Sprinter van to transport passengers for compensation, such that all these defendants were engaged in a joint enterprise and or agency relationship with defendant Carter. Defendant Robinson, good to go, and executive elite are liable under the doctrine of respondent superior for the torturous acts and omissions of their agents, employees, servants, or individuals with whom they are in a joint enterprise. These acts and omissions include, but are not limited to, the acts and omissions committed by defendant Carter on March 1st, 2025. Defendants Robinson, good to go, and or executive elite negligently entrusted the Mercedes Sprinter van to Carter, who was unfit and, let me repeat myself, who was unfit to operate the Sprinter van and who had no insurance despite using, he had no insurance. Y'all see, that's what it said right here. But anyway, let's continue. No insurance despite using the van to transport passengers for compensation. Defendants Robinson, good to go, and or executive elite are common carriers of passengers who negligently selected, hired, qualified, retained, and trained Carter. As a direct and proximate result of the foregoing breaches of duties, Angie Stone suffered the losses in, okay, so that's a repeat. Okay, so we're going to go to count 9, attorney fees and litigation expenses. Okay, Plaintiffs realleges and incorporates each of the following. So defendants have acted in bad faith, have been stubbornly uh, litigious, and have caused plaintiffs unnecessary trouble and expense, such as plaintiffs seek to recover from defendants all costs of litigation, including attorney fees and expenses. And then damages. The damages claimed by plaintiffs were approximately caused by the torturous acts and omissions of defendants, for which they are liable jointly and severally. As a direct result of the defendant's negligent acts and omissions, Angie Stone suffered severe personal injuries, conscious pain and suffering, shock, fright, and terror, and ultimately death. Plaintiff claimed and seek all damages available at law for the wrongful death of Angie Stone. Plaintiff Michael Archer II, as the administrator of the estate of Angie Stone, claims all compensation. Get it out, boy. Compensatory damages suffered by Angie Stone, which her estate is entitled to recover, but are not limited to pre-impact and post-impact shock, fright, and terror that Angie Stone experienced prior to and during the subject collision. All components of the mental and physical pain and suffering and general damages endured by Angie Stone, all emergency transportation expenses, medical bills, funeral and burial expenses for Angie Stone, punitive damages to punish, penalize, and deter defendants, attorney fees and litigation expenses, and all other damages recoverable by law. Now, here goes Sheila Hopkins, as a direct result of the defendant's negligent acts or omissions. Sheila Hopkins suffered severe personal injuries, pain and suffering, shock, fright, and terror, and ongoing physical, mental, and emotional pain and trauma. Plaintiff Sheila Hopkins claims all damages for which she is entitled to recover, including but not limited to pre-impact and post-impact shock, fright, and terror that Sheila Hopkins experienced prior to and during the subject collisions. All components of the mental and physical pain and suffering and general damages endured by Sheila Hopkins. All past and future medical bills for Sheila Hopkins for treatment related to the subject collisions. Punitive damages to punish, penalize, and or deter defendants. Attorney fees and litigation expenses, and all other damages recoverable by law. And as y'all can see, that is the end of this actual court document. So I'm interested to see this case go to trial, because 9 times out of 10, when it comes down to vehicles and when it comes down to safety systems that are put in place, and to see them fail, and not only did it fail, but it did cause a life. I am waiting to see what this lawsuit turns into. But most importantly, when it comes down to Angie Stone, I hope and pray that this goes to trial. Now, as y'all do know, in big corporations, they like to go ahead and settle. But I would like for this actual trial, in my opinion, now this is my opinion and my opinion alone, I would like to see this trial. I would like to see this case go to trial. Okay. But anyway, that's my opinion. But if you like what you see here today, like, share, subscribe. And until next time, and as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, y'all have a good one.